So I introduced myself. My name is Derek. I'm a counselor to Assistant Secretary Washburn, and I'll let Jennifer introduce.
Good morning, everyone. My name is Jennifer Romero. I'm a senior advisor to Secretary Jewell at the Department of the Interior.
And I know out front, if you guys signed in, you met the wonderful Annette Romero. She's in our Department of Regulatory Affairs, and we have Craig Dorsett around here as well too. Craig Dorsett's in the Office of Policy, Management, and Budget. So those are the federal folks here this morning. I know we have a tribal leader here from Kauanoe. Would you like to introduce yourself, sir?
Thank you. Thanks again for the Tulalip's and your beautiful place and allowing people to come here and visit. My name is Bill Starrood. I'm the chairman of the Puyallup Indian Tribe. We're out down there by Tacoma, Washington. I have some Hawaiian friends, and I was just over in Hawaii like last week visiting some of my Hawaiian friends. And the concern that my Hawaiian friends had was that what are these hearings taking place? And why are the Indian tribes having a comment into your internal, personal, tribal world? Well, I'm here to say that we do not have a place in your internal tribal world, and that you have some very important questions that you have to ask. You have some important things you have to say. Indian tribes over here don't have any input into that process. I'm just saying that for the record. But this is your world. This is your fight. This isn't the tribal over on the mainland's fight. We'll support what you come up with, guaranteed, but this is your fight. And I just want you people to hear that. And I want Interior to hear it as well, that this is your fight, this is your government, and this is your world. Thank you.
Thank you, Chair. So with that statement, I guess, so this is, I'm here on behalf of Indian Affairs, and we've been working, as a federal team on this matter, and just a little bit of background behind why Indian Affairs is involved. And the short of it is when the concept of acknowledging the government-to-government relationship with the peoples was brought up in the Department of Interior, Indian Affairs is, we've been doing this since the 1930s. And so I kind of see our involvement in this matter as more like a technical assistance involvement. It's definitely not trying to swoop Native Hawaiians under the umbrella of Indian Affairs, but it's more, when we look at this issue, Indian Affairs has a long history with the Indian Organization Act, the Oklahoma Indian Welfare Act, the Alaska amendments to the IRA, the federal acknowledgement process, all of those different types of ways that tribes come into being. We have reaffirmation processes that we go through for tribes that were administratively left off the acknowledgement list, and it's kind of a mistake by the Department of Interior. So we have a lot of analysis that we go through to acknowledge that government-to-government relationship. So I think when this initiative was set forth, I think the thought was that since Indian Affairs has dealt so much with acknowledging that government-to-government relationship, that we should be kind of at the table. And the consultations, I see them more as tribes being able to give their input as to what works from the processes that they've been through. We have a lot of tribes that have been acknowledged through the federal acknowledgement process. We have several that have been acknowledged through reaffirmation. A lot of tribes are IRA tribes. A lot of tribes in Alaska were organized under the Alaska amendments to the IRA. And so just their history of it, it's not, we're going through, right now we're also doing a separate rulemaking process for the federal acknowledgement process. And in that rulemaking process, that's for continental United States folks that are petitioning for federal acknowledgement. And so if the thought was to swoop Native Hawaiians into Indian Affairs, then we would have probably lumped it within that federal acknowledgement process. But this is separate and distinct, and it's something that you hear today. It's not the federal acknowledgement process. It's not the reorganization process. But when you look at those two processes, they might have components of there that might assist in any type of potential framework that we might be looking at in the future that addresses Native Hawaiians. So with that, I wanted to turn it over to Jennifer to give a little bit of background. And we initially framed this presentation for tribal leaders in case there was a historical, information that needed to be told to tribal leaders for them to understand why we're here today and why we're talking about federal acknowledgement, possibly for Native Hawaiian community. And so that's why you see brief discussion of Native Hawaiian history. So I'll turn it over to Jennifer. I think she's going to kind of abbreviate that portion of the presentation, but Jennifer, we're on.
Thanks, Derek. Good morning again to all of you. Thank you so much for being here, and on behalf of the Department of Interior and Secretary Joel, we welcome you, and thanks again for taking time on your schedules to come and listen. Before I begin the overview of the advance notice of proposed rulemaking, let me give just a little bit of brief background on Native Hawaiian affairs. Native Hawaiians, like Native Americans and Alaska Natives on the mainland, are distinct, indigenous, Native people who lived and exercised sovereignty over their lands centuries before European contact and the formation of a federal government. Native Hawaiians continue to maintain their national identity as a distinct people with a unique language, history, culture, and ancestral land base. Yet despite these attributes, they're the only indigenous people of the United States that do not currently have a government-to-government relationship with the federal government. So no federal regulations currently exist for recognizing a Native Hawaiian government. So with that, let me tell you what I'm here to do today. I will be giving you an understanding of how the advance notice of proposed rulemaking, and I'll abbreviate that by saying the ANPRM, how the ANPRM was developed and why. I'll also briefly go over the 5 questions that we've asked the Native Hawaiian community and other stakeholders in the ANPRM. So let me begin with a little bit of background on the development of the ANPRM. When was this document released? And I believe you have in your materials the 5 questions, as well as some more information on the proposed rulemaking. But on July 18th, Secretary Joel announced a first step to consider reestablishing a government-to-government relationship with the Native Hawaiian community and the United States. The ANPRM was posted in the Federal Register shortly thereafter. After the publication, the federal team of Interior and Justice officials, including myself, embarked on a nearly 3-week journey to the Hawaiian Islands. We conducted 15 meetings on all the major islands in Hawaii. We collected over 45 hours of oral testimony during these community meetings. But in addition to those meetings, we also had smaller community meetings, smaller stakeholder meetings in between the larger ones. We collected written submission testimony based on the ANPRM, and also heard directly from those small community organizations. Those organizations, and we did meet informally, these were not on the record. This is strictly a talk story with these small organizations, which included the Office of Hawaiian Affairs, the Department of Hawaiian Homelands, Homestead Community, the Rural Societies, the Li'i Trusts, in settings really just like this one. It was an open forum. And we at the Department of the Interior felt that it was critically important that we hear directly from the community and we have a robust dialogue with the Native Hawaiian community, and that we really heard from the people directly. So that was our goal. We set out to have these public meetings, 15 of them throughout the islands, but we also wanted to meet directly in the community to talk story and to really understand people's feelings about the ANPRM. So that's the timing of the ANPRM, and let me talk about why we undertook this process. So a lot of the questions that we got and the feedback we got in these smaller community meetings had to do with why are we here? Who asked us to undertake this process? So let me flesh that out a little bit. The ANPRM responds to requests from both the Hawaiian congressional community, and the Native Hawaiian community rather, and the Hawaiian congressional delegation. The Native Hawaiians elected political leaders, and then the local and at the national level, for the Department of Interior to consider developing an administrative process to create an option for the Native Hawaiian community to reestablish a government-to-government relationship with the United States. The process really builds on the 1993 apology resolution. In case you're unfamiliar with that, in 1993, the United States Congress formally apologized for its role in the overthrow of the Hawaiian Kingdom and acknowledged that that overthrow was illegal. In 1993, once that resolution was passed, it kicked off a reconciliation process. And in the year 2000, or rather in 1999, another federal team of Interior and Justice officials went to Hawaii on a much smaller scale and had meetings with the Native Hawaiian community. And those meetings really centered on issues close to the Native Hawaiian community, education, employment, healthcare, these types of issues that the Native Hawaiian community really felt was important to self-determination and self-governance of their community. And as a result of those meetings that happened in 1999, a year later, a report came out. It's called the Reconciliation Report. And that report gave as its top recommendation, its highest priority. Its recommendation to the United States was that the Native Hawaiian community be given the opportunity to reestablish and reorganize and petition the United States for federal recognition. So based on those two critical moments in time, we at the Department of Interior, hearing from local and national leaders over the past 2 decades, decided to lay the groundwork for the ANPRM in this important undertaking. So that's sort of the who behind the ANPRM and why we were asked to undertake this process. So let me then now address the why. Why is the ANPRM proposed? The United States, the United States has a special and political relationship with the Native Hawaiian community based on over 150 statutes conferring benefits on the Native Hawaiian community. Specifically, Congress has established special Native Hawaiian programs in the area of healthcare, education, loans, and employment. And 2 very prominent examples of these benefits codified in statute is the Native Hawaiian Healthcare Improvement Act and the Native Hawaiian Education Act. The United States has also enacted statutes to preserve Native Hawaiian culture, Native Hawaiian language, and historical sites. So, as I said before, the ANPRM is really proposed to give Native Hawaiians the option of strengthening their self-determination and their self-governance by reestablishing government-to-government relationship. But really, another key reason is to better implement these federal benefits that the Native Hawaiian community already has. So, as I said before, Native Hawaiians are the only indigenous population in the United States and the largest one that does not have a government-to-government relationship with the United States, but it does have a special and political relationship already with the United States. So, with that, let me talk about the ANPRM and what does it do. The ANPRM asks 5 threshold questions. The first question is the big one. Should the Secretary propose an administrative rule to reestablish a government-to-government relationship with the Native Hawaiian community? If the answer is no, then there's really no need to consider any of the other questions. But that is really the big question here. Does the Native Hawaiian community, would they like to re-engage? Would they like to reestablish and reorganize as a formal government and petition the United States for acknowledgement? If, again, as I said, if the Native Hawaiian community prefers the status quo, then the Department of Interior will take no action. But if the answer is yes, then the next 2 questions concern facilitation of a reorganized government. The second question asks, really, should the United States facilitate? Should it have a role in assisting the Native Hawaiian community in reestablishing a government? If the answer is yes, then what process should the United States use in facilitating the reestablishment of this government? We're asking your opinion. We're asking for your expertise and your thoughts on the process. Those are the second and third questions. The final 2 questions consider federal recognition. the question number 4 is, should the secretary wait for the community, with the assistance of the state of Hawaii, to complete its nation building that's already underway, and rely on that reorganization process? So if the answer is yes to number 4, then the final question is, how should the secretary acknowledge this new government once formed and go on to establish a government-to-government relationship with the Native Hawaiian community? So those are the 5 questions. There are other questions in the AMPRM that are causing a bit of confusion. Some people say, well, you know, these are 5 threshold questions, but there's actually 19. Well, yeah, it is confusing. There are 19 questions, but the 5 threshold questions are threshold questions. The remaining 19 questions are really there to assist commenters on thinking through these questions and maybe coming up with ideas on how to address the 5 questions. So you'll see in later on in the AMPM toward the end, these other questions that really are meant to flesh out and assist, and they're not additional questions. So just wanted to make that clear that they're just the 5 questions that we're asking. So let me conclude by talking a little bit about what the AMPRM does concern and what it does not concern. And I think this is really important for the community to understand. The AMPRM does not concern 4 things. Number 1, it does not concern international law. Nothing in the AMPRM would alter the fundamental political and trust relationship between the Native Hawaiian community and the United States that's been established by Congress and codified through those 150 statutes that I mentioned earlier. So it does not concern international law. The second thing it does not concern is membership. Presumably a Native Hawaiian government, once formed, would exercise its sovereign prerogative and, operating under a constitution or other governing document, could define its membership criteria. There is a seminal case on this matter with respect to Indian tribal membership, and it's called Santa Clara v. Martinez. And in that decision, the United States Supreme Court determined that membership in a tribe is an internal matter. So the United States does not have a role in defining membership. So the AMPRM has nothing to do with membership. The third thing the AMPRM does not concern is land. The AMPRM does not address land whatsoever. Any federal rule that results would not have any direct impact on the status of Hawaiian homelands. There is a separate statute that concerns Hawaiian homelands, and we are not, the AMPRM process does not concern that particular issue. The last thing that the AMPRM does not concern is reparations and compensation for past wrong. The 1993 apology resolution preserved these claims, but the AMPRM does not address them. So let me end my presentation by emphasizing that there's been a lot of hard work that's come, that we really, the Native Hawaiian community, the Native Hawaiian the Hawaiian congressional delegation, the local leaders, the state legislatures, it's been a lot of hard work in getting to this point. It's only been 21 years since the Native Hawaiian community has had a voice in steering a path towards self-determination. And the 21-year mark is really a nod to the 1993 Apology Act. That's really when we feel that the reconciliation process between the United States and the Native Hawaiian community was kicked off. And there's been so many things that have happened during those little over 2 decades. But so far, these important building blocks, the apology resolution, the reconciliation report, and the federal recognition legislation that was proposed by former Senator Akaka, these efforts were important, but ultimately the legislative effort for federal recognition for Native Hawaiian community failed. When Senator Akaka retired, no other Hawaiian congressional leader has taken up the mantle and introduced similar federal recognition legislation. And there's a host of reasons why legislation on that particular path is something that may not be prudent at this time because of the frankly toxic political environment that we're in right now. But we feel that it was important, and I know that the Obama administration feels strongly in its commitment to attempt to carry forward to fruition the goals that were set in motion by Senator Kaka and the other Hawaiian congressional delegation and their leaders to work towards giving the Hawaiian community an option to pursue self-determination and self-governance in their lifetimes. But let me just underscore that this effort is ultimately the community's decision. It's this decision on how and whether to move forward towards self-determination and self-governance. The United States is simply here to facilitate and support that choice. So the comment deadline on the AMPR is August 19th. We encourage you to submit written comments at regulations.gov, and the information is up on the screen here. You can also mail your comments in directly to the Office of the Secretary by United States mail, or if you have your comments here with you today, I'm happy to take them back to DC with me. I think that's all I have. Should we open it up?
Yeah, thank you, Jennifer. So just real quick before we open it up to comments and statements, I just want to remind everybody we have a court reporter here. So before you make your statement or ask your question, please state your name clearly for the record, so we can have an accurate record of the discussion that went on this morning. So we have a lot of people here, which is great. We're going to have a lot of comments this morning, and we're going to work through a lot of items that we just discussed here. Before we start, I just want to say, if everybody could be respectful, that we have a lot of people in the room who want to get through. Make sure everybody has a chance to comment first before we go to second comments by individuals. And so please try to limit your comments between 3 and 5 minutes, I guess. So I guess at this point we'll open it up, and we really want to hear from you guys. So is there anybody in the room that would like to make a first statement?
Thank you. My name is Daniel Conquiki III. No, not from the Pacific Northwest, it's Uncle Danny. I am ethnic Hawaiian, born and raised on the island of Lanai. To your response to your question 1, should the Secretary of DOI write an administrative rule? I'd say yes, definitely yes. I appreciate the fact that for the years that we have been trying to gain recognition that with the Hawaii Legislature's Act 195 and now with you and what you're offering, that the door for me is open. And the thing I want to make sure is that we don't close it on ourselves. Question 2 was, what role should DOI play in this? And my thing to you is that advise, assist, make recommendations. We may not be Native Americans, but you have gone through the process of helping Native Americans create a self-government. And I think it's time that we kind of said, hey, let's learn from the mistakes, take advantage of the things that work. And this is, to me, again, where DOI needs to step into the bag. For me, the most critical thing I think I ask of DOI is that we have a notorious reputation among Hawaiians to be kind of not timely. And my thing would be, I would say to DOI, for me, the most critical thing you can do is to create a realistic date time frame where things can be done. Otherwise, you're going to be meeting again 5 years from now. So my thing again, that would be, again, I think, the one function especially. And for the Hawaiian community, I think the critical thing right now is creating a role, identifying those of us who are qualified to be in the process of creating the self-government. As to eligibility, I've heard pros and cons going to HH, the Hawaiian Homes Act of 1927, which creates some criterion for who are Native Hawaiians. Act 195 by the state of Hawaii creates more criterion about who Hawaiians are. Again, I think the criterion is there, and I think, but for all the advice and recommendation that DOI makes, I think the ultimate thing is that eventually the decision has to be ours. What process we use to create this government, what process we use to identify qualified Hawaiians should be ours, not Fred's. Question 17, and I think kind of asked about your role and the working together to create the Constitution, the government. And I think the question kind of boiled down to, should it be with Hawaiian community, state of Hawaii, and working through DOI. My thing is, the one thing I really would like to make sure we don't do is, we don't get caught up in the federal process. We have such a divisive Congress that we will never get any place. So my recommendation would be certainly that DOI be involved in that process. I think question 18 was whether you should have approval, disapproval authority, and I think you should. If you're going to be responsible for setting up the process, I think eventually you should have the authority to approve, disapprove actions, recommendations that are made. Ultimately, though, there should be a caveat that the decision-making is not yours, but ours. I think in conclusion, again, I appreciate everybody coming here, and I know that it's a complex and complicated process, and it's not going to be done tomorrow. And there are a lot of pros, a lot of cons. I understand that some of your reactions back in Hawaii were not the most positive, but I think, again, most of us really are looking forward to a self-governance system. And I appreciate, again, the fact that you're opening this up to all of us and to the Hawaiian community. But again, eventually I say to DOI, go ahead and make recommendations. You've done this, you've seen it, how it works and how it doesn't work with the Native American things. And we don't need to reinvent the wheel. Just make recommendations on how you think it could work for us. But again, eventually, let us make that decision. Again, my name is Daniel Compton III. I live here in Seattle. Being away from Hawaii for 40 years, I have a kind of a different perception of. I am concerned mostly about our people.